So, good afternoon, everyone. I'm your host, Francis, and I'm very pleased to be able to welcome our guest speaker, Dr. William A. Huber, from Analysis and Inference. He'll be presenting today on statistics in the US courtroom. So just a little bit about Dr. William A. Huber. He specializes in environmental statistics, investigation, and support. During a 35-year career as a consultant, he has testified as a statistical expert in litigation and arbitration, led research and development of data visualization software, provided statistical support for hundreds of investigations of water, soils, groundwater, wastewater, and air quality, developed custom and commercial statistical software for sampling, spatial data analysis, database querying, economic analysis and forecasting, and published research in geospatial analysis, statistics and law, risk assessment and quantum mechanics. He has taught mathematics and statistics and GIS for professional organizations at many graduate and undergraduate institutions. He's also helped nurture small businesses, volunteer organizations, and online communities as an investor or elected board member. So he has a wide breadth of experience and knowledge, and I'm really happy to welcome him to the floor. So if you'd like to start sharing your slides, Bill.
I think you have to stop sharing yours, Francis.
I have.
Okay, I'll try again. How does that look?
That looks great.
Well, thank you.
I'm just going to mute everyone first. Apologies. I think a few people have their mics muted. Okay, great. Go ahead.
Well, thank you all for spending some time with us this afternoon. I appreciate it. It's always good to have an audience. I welcome questions. We'll reserve some time at the end of this hour for discussion. And I suppose I should thank you, Francis and Scott Ferson, for inviting me, or really shanghaiing me into doing this. But I'm always happy to have an opportunity to share ideas with people and welcome your reactions, criticism, anything else that you would like to reflect on.
Sorry to interrupt, Bill.
Yeah, go ahead.
You might want to move the gallery just out of the way, because I think it's in front of the
slides. Is it in the way? So I apologize. I didn't realize that Zoom couldn't distinguish. How does that look now?
Yeah, that's perfect.
Okay. As Francis mentioned, I've been engaged in the last few years quite a bit in serving as a statistical expert witness in US courtrooms, and in fact, more recently in some Canadian courts. This brings a very wide and interesting variety of cases to my office. I'd like to share two of them and another class of cases that I've been involved in a lot. The first one is the Crawford versus Alachua County in the Northern District of Florida, where I want to show you how far simply visualizing data can go. The second one is of interest in part because it was really the precursor to an ongoing case involving a hot topic these days, which is social justice in the United States and the disparate impact of incarceration in certain protected groups, such as African Americans. I'm involved with the same experts in another case that involves the same issues in the District Court of Connecticut and seems likely to proceed to the US Supreme Court in a few years once it gets tried in district court, because neither side wants to settle and both have points to make. Cheating cases. I have been fielding more and more cases where people, often students, are accused of cheating, typically on standardized exams. And some of them have the resources to fight back. I'm finding that there are a lot of commonalities to these cases and some very interesting things that can be said about them. So I'm going to wind up by discussing that group of cases with you. All of the cases that I'm going to describe to you today take place in the United States. So whether or not I mention the US, it's going to be in US courts, but there's a great similarity between those courts and those in the United Kingdom and even elsewhere in the world. In the US, we have a lot of legislation that guarantees people, especially minority groups, some protection. They include the acts that are mentioned in this slide. In this particular case, the plaintiff had been a mid-level manager in a county government in the United States for many years, and eventually decided to quit. And after quitting, filed suit against the county, claiming that for many years that she had been overworked and underpaid. So I have some quotations from her complaint here in this slide. One of the things I've learned in working in litigation support over the last few years, it's very useful to take a look at the actual complaints that are made in the case, because it shows you the questions that you really need to address, the kinds of allegations that are made. So to proceed with this, we contacted the county IT people, those who maintained databases, and discovered with their help that they had extensive records of certain kinds of activities of all of their employees, both current and former. This slide lists some of them, and you can see some of the printouts in the illustration in the upper right. We had many, many megabytes of email archives that involved this employee. We had her calendars, her appointment records over these years. We had records of the calls on her county telephone, not her personal one. Key card entries refer to the use of electronic cards to get through certain protected areas, to open doors and close doors within the building in which she worked. Timesheet entries, of course, for the hours that she did work or claimed that she worked, and so on and so forth. So among the interesting things here was the variety and complexity of the data. This looked like a case that was going to involve an awful lot of data processing and screening. And then if we could develop some statistical models to assess what was going on, it looked to me like that was going to be a complex and difficult and involved project. But first things first, we had to process the data. So here is the defense plan that I outlined. Of course, I'm working for the defense for the county government here. The step one was the organizing and documentation of the data. I have some illustrations of the data. It's not expected that you can read those in any kind of detail. But after collecting all these data, and there were enough of them that we actually had to just overnight an entire disk drive of all these data, I began assembling them. And what I realized would be very helpful would be just to create a timeline of all these different events. I'll describe this timeline to you in a little bit more detail in the subsequent slides. But the basic visualization scheme, as you can see on the bottom axis, is that the time covered by the case, which was about 1.5 years, spending the middle of 2012 through when she filed suit in November of 2013, flows from left to right. Each day is represented by a vertical strip, and within that vertical strip, the times during the day are located vertically, as indicated by the axes to the right and to the left. Here is a detail of a small portion of what I came to call the freeze of this timeline. Because very little activity occurred in the middle of the night, but sometimes this person was working at midnight or 1 or even 2 a.m., I elected to break my days at 4 in the morning rather than conventionally at midnight. I realize it's a little strange, but it meant that I didn't have to, that everything could be situated vertically in the middle of the graphics. I eventually classified events in several ways. Things like logs of days worked, which would span 8 or 9 hours, I thought of as being intervals These were times when either we knew that the plaintiff definitely was working, or if it was a vacation record, it was times when she definitely was not working. Other times were point times. They were, say, the time and date stamp on an email. So when an email is sent by her, we knew that she was probably working on that email at that time and likely for a long time before then, but the only clear information we had was the timestamp of the email. So on these graphics, the intervals are shown as visual graphical intervals, vertical strips that you see here. And the point events are shown as different points, color-coded and shape-coded to indicate the different kinds of activities. So having this in front of me, just in draft form, at this point I've not shared it with anybody, I could immediately start comparing this visual representation of the raw data with some of the claims in the complaint. For instance, she claimed that she was working on a daily basis from 8 a.m. through 11 p.m. To help me evaluate that, I simply shaded that period from 8 a.m. to 11 p.m. in a slightly darker shade than the rest of it, as you can see here. I can see that contention that she's working from 8 a.m. through 11 p.m. is generally true, but it's exaggerated. She rarely worked after about 8 to 9 p.m. She claimed that throughout this period that she had to work until late hours of the night without pay. Well, here we can see the extent to which that might be true. And sure enough, we have some positive evidence from time to time, maybe about once every week or so, that she would be doing a little bit something, maybe until midnight or later, but it certainly wasn't all the time. So having completed this, I shared it with our client, the county attorney, late on a Friday afternoon. That was the July 1st. I didn't expect him to share it with the plaintiff's attorneys. I expected him to get back to me and we could discuss the next steps, but he promptly forwarded it to them, and in short order, the case was settled. What happened there, I think, and this is based on my subsequent conversations with the attorney, is that for the first time, the opposing attorneys, the one the plaintiff had hired, could see the data and could evaluate for themselves the likelihood or the potential truth of all the claims that their client was making. And seeing that, they realized that they didn't have much of a case. They did get some money for the settlement, enough to pay themselves and to save a little bit of face, but a lot less than they were asking for. So some of the lessons that I drew from this, and I've drawn from other situations like this, is that in this slide I say sometimes, but in my experience, it is frequently the case that you do not have to perform formal statistical analyses. You don't have to do hypothesis tests. You don't have to do formal experimental designs or whatever. Frequently, if you have the opportunity to see the data in a clear and honest and undistorted fashion, that can help you make your decisions or tell your story to somebody, help them understand what's going on. Intuitive graphics speak for themselves. And in particular, if you can display the raw data, then that can be a very powerful analytical tool. Everybody can appreciate that. It has a really visceral impact. Second case now, turning to something a little bit more important. It's Alexander versus Edgewood Management Corporation et al. There were multiple defendants. This is Mr. Alexander on the right. He's a good guy. He was a local activist in Washington, D.C. area. At one point, shortly before he retired, shortly before this photograph was taken, he encountered an altercation between a cop on the street and a neighbor and attempted to intervene and was promptly arrested for a misdemeanor, put in jail overnight, but it created a criminal record for him. He apparently decided to exploit this shortly thereafter and tried to sign up for publicly assisted housing at the point when he retired. So it was housing designed to support seniors, senior living facilities. fully expecting that his criminal record might disqualify him. And sure enough, it did. Then he turned around and filed suit. Up at the top of the slide is a picture of one of the facilities to which he was applying, called the View. So all three of these facilities invoked his criminal history record as at least one of the reasons that they were denying his application. This is an example of a disparate impact claim. So let me back up a little bit and give you a little bit of history. Civil rights legislation happened in force in the 1960s in the United States. It took a little bit longer for people to realize the implications, but by the late 1970s, major suits were reaching the US Supreme Court. And throughout the 70s and the 80s and the 90s, several different theories of discrimination emerged. Early on, the cases that were debated were those that were obvious cases of discrimination. Discrimination is a pattern of practices or procedures that have an intention of creating a different effect on a protected group, such as older people, women, Black people, whatever. But after this initial spate of cases, we're getting into the late 1980s and late 1990s now, the issues became subtler and no longer was intent part of the theory. And the courts have developed a disparate impact theory that does not require the plaintiff to establish an intent to discriminate. It only requires a demonstration that the practices, that defendants' practices have resulted in different effects for different groups compared to some reference group, typically white males in the United States. This has been likened to a kind of a ping pong game. In order to pursue a disparate impact case, the plaintiff first has to establish what's called a prima facie case. They have to identify the policy that was causing the disparate impact. They have to demonstrate that there was an impact, and they have to establish a causal connection. It's not just some kind of correlation. If they succeed at all three of those, then the ball basically becomes in the defendant's court, and the defendant either has to show that there are errors in those demonstrations, or barring that, it has to show that there was some good, valid reason for these policies or procedures to be in effect. This is called a business necessity defense. For instance, firefighters and police departments have been sued for discriminating against women. And part of the defense has been, well, we have to have certain physical standards in order to admit people to our academies. And so we have to, we need people who can lift a certain weight and can run in full gear a certain distance for a certain time. And it just so happens that fewer women can meet those thresholds, but we have to have those thresholds in order to employ people who can do their jobs. So plaintiff's strategy in the Alexander case was to argue that the tenant screening plans, so these are formal written documents that are used to say what are the criteria for accepting or rejecting people who want housing, cause disparate impact to African Americans because African Americans are incarcerated at much higher rates than whites in the United States. We now all know this due to recent events, especially in the George Floyd case. And therefore, any kind of screening plan that uses the existence of a criminal record to reject applicants automatically is related to race and therefore is discriminatory. So kind of an indirect argument. So here's a diagram of plaintiff's strategy. Let me give you a little bit of background about this. In when I was talking about the prima facie case, and I'll back up on my slides here a little bit. It's talking about the second one, demonstrating that there has been an impact. This is where statisticians typically become involved. How do you demonstrate that there was an impact? Very difficult to do when there's just one person involved claiming that, say, she was discriminated in employment because she was female. Typically, what you have to do is you have to evaluate a group of people and demonstrate based on the experiences of that group that there has been some kind of impact. And that typically requires a statistical analysis of those experiences. There are two general strategies that have emerged. One of them is called an applicant pool strategy, where the plaintiff identifies all possible people who might, say, want to be employed by a local restaurant or a local university, or might be applicants for public housing. And among them, identify those who might potentially be qualified, split them into the protected group, the non-protected group, take a look at data concerning the rates at which those people have generally been selected for employment or housing or whatever, compare those rates by the groups, and if you find a statistically significant difference, you may conclude that there is a disparate impact. The other strategy is called an applicant flow strategy. I'll explain that to you in a few more slides. So to carry out the strategy, typically you have to hire expert witnesses, people who claim to be experts in housing or race or employment, as well as statistics. Plaintiff in this case hired two fairly well-known experts. These are good guys. They've dedicated their careers to studying social injustices. Christopher Wildman is a Princeton graduate, and for the last 20 years or so has been studying the impacts of this higher level of incarceration among Black people and poor people. Dr. Alan Parnell has been dedicating his career as a sociologist to studying disparities in housing. So they tag teamed here. Dr. Wildman was responsible for establishing that there really is this difference in incarceration rates between Blacks and whites, but especially at the local level, because one of the things that the courts have insisted is you can't just pull out general statistics out of thin air or for the entire country and apply them directly to the particular case in which you're working. You have to produce statistics that are directly relevant to the particular employer or region or municipality or government area or whatever that the case concerns. So what Dr. Wildman did is he took a long-term longitudinal study called the NLSY 79 and drilled down into some of the details of that study to produce some fairly specific estimates of disparities. This is his table right here. Say a little bit about the NLSY 79, even though it's kind of specialized, but it's important. Back in the late 1970s, this study was funded, and through separate various means, it's not a perfectly random sample, some 12,000 people who were in their late teens were identified, and they have been followed constantly since. Once a year, initially, they were asked a long, detailed list of questions, hundreds of questions given by interview, which are then recorded in a database. And every year, these questions were asked again, and they went into all kinds of details. Where are you currently residing? What's your family situation? What's your work life like? How much money do you make? And so on and so forth. It's still ongoing. And the way Wildman exploits this is that he can find answers of the form, say, answers to the questions, where are you living? And sometimes the answer is in jail. And using these answers, he can track the incarceration rates over time of different kinds of groups of people. And from that, he draws these statistics. Dr. Parnell then takes over, and his job in the Alexander case, as well as in the ongoing cases in which these two are working, is to then take Wildman's somewhat generic statistics and show that they apply and how they apply to the specific circumstances at hand. So to do this, he collected data about the Washington, D.C., as well as the regional Maryland and Virginia housing markets. And he took some of Wildman's numbers that you see here circled in orange at the top. He took some other numbers from the American Community Survey. And let me pause for a second and say a tiny bit about the ACS. The American Community Survey is run by the census. You can easily identify, search, and download those data from the ACS website, supported by the census. It's a rich supplement to the kind of generic limited data that the census gathers every 5 or 10 years here. But it is not a complete census. The Census Bureau asks a large number, I think many tens of thousands of households to fill out a detailed survey once a month. And over the course of every 3 to 5 years, it reaches a large fraction of all the households. But it's the result of a survey, and all the data that the census produces for the ACS are statistical estimates created by the census. And to emphasize that, the census actually simultaneously publishes margins of error for all of those results. At any rate, Dr. Parnell extracted some data about overall populations shown here, as well as some more detailed populations from the ACS. And from those, he produced a z-score and finally a level of significance, a p-value. Now, why is p important? You know this as statisticians or consumers of statistics, but the important thing here is I mentioned the evolution of a disparate impact theory in the US courts over the years and the role of statisticians in developing a DI case. What the courts have also said is that a reasonable standard for establishing that there is a significant difference, by which they really mean important, has been variously articulated as a p-value less than 5% or a sigma, equivalently a z-score, of somewhere between 2 and 3. That's a quotation. Now, the meaningfulness of that has been debated and will go on being debated, but that's there in case law, and that's what the statisticians and the lawyers are going to pay attention to. So when Dr. Parnell achieves a p-value of less than 0.01, he's probably thinking, aha, I have made this prima facie case. I have established disparate impact. That's its importance. But let's go into some of the details. I'm showing you here a screenshot from a web app that Dr. Parnell favors. It's not his web app, it's a generic one. You can see it up there in soxscistatistics.com. You can even go on there now and type in the numbers and see what it does. It is a standard two-tailed normal theory z-test of 2 binomial proportions. Let's see, do I have a detail of this? No, I don't have too many details. So let me explain it a little bit better. It's a standard 2x2 table. If you imagine that you could have observed, say you've observed 1 million white people, and you found that 20,000 were incarcerated, and you also observed 500,000 Black people, and you found that 50,000 people were incarcerated, you can then construct a standard 2x2 table and make a chi-squared test of independence, which is equivalent essentially to the z-test, and determine whether there is a difference in proportion between those two groups. That's basically all that's going on. Here's a summary of it. From the surveys, the NLSY 79 and the ACS, the two experts variously derived their data and the corresponding statistical estimates. Dr. Parnell performed some multiplications to obtain the counts. He conducts the z-test that I just showed you. Pause for just a few seconds to let you think about this, about what the basic error is. And while you're thinking, I'll just remark that although certainly in retrospect, after I explained it, I hope it will be obvious, I have found it extraordinarily challenging to explain this lawyer to lay people, especially to lawyers and the courts. When I think hard about statistics, I come back to what has been called the tickets in a box model, or more formally an EARN model. If you want to perform a statistical test or do any kind of probability calculations, it is very helpful to try to draw a clear parallel between what you're looking at and the concept of putting a bunch of balls in an urn, mixing them up randomly, and drawing one or more of them out at random. That's the sampling process. So for instance, to model what I just described in that 2x2 table, we might think of having two jars. One jar that describes all African Americans, or maybe all adult African Americans in the Washington, D.C. area. And for each one, we have a slip of paper on which we write their name and some of their characteristics, perhaps. And another one on which we write the names of all white Americans, as well as their characteristics. And among the characteristics on all these slips of paper, we include whether they have a criminal record that would come to the attention of a housing decision maker. So now we can model a fair process, one that has no discrimination, as if we're randomly reaching into a well-mixed jar of tickets and pulling out a bunch of tickets, observing how many of those have been incarcerated, observing how many of those have been accepted for housing. It is that kind of model, that kind of probability sampling model, that underpins the calculations of p-values in all statistical hypothesis tests. But the important thing here in this model is that it is modeling actual observations. It's modeling actual samples. Here it is. Here are the 2x2 tables, 2 columns for incarcerated or not, 2 rows for race, that are really at the foundation of Dr. Parnell's analyses. In order for his p-value calculations to be valid, this table has to be actual data. These have to be real counts observed with no error whatsoever. But as I explained in previous slides, these are not counts. These are estimates multiplied by estimates, each of them with fairly sizable standard errors. For this reason alone, the p-value is erroneous. Now, in this particular case, I think that if we accounted properly for the margins of error in those estimates, we would conclude that there is still a lack of independence in these tables. That is, there's still a difference in the experiences of African Americans and white people in the Washington, D.C. area concerning criminal records. That would be the beginning, I think, of a much stronger case that the plaintiffs could have made. All right, so let me switch a little bit before I give you a summary. I said earlier that there are 2 general approaches to a case like this: the applicant flow pool analysis I've just described and the applicant flow analysis. The applicant flow analysis, rather than looking at hypothetical large groups of people who might be qualified for employment or housing or whatever, we look at the people who actually did apply. That's the applicant flow. In this case, it was possible. Now I'm describing my own work, working for the defense. I was able to obtain, and this is data that were available to the plaintiff too, I was able to obtain actual records of people who had applied to some of these facilities over the recent several years. And with some effort, was able to obtain reliable information about their racial classification. Now here's where a knowledge of the actual geography helps. Washington, D.C., especially in the areas where Morris Alexander lived and applied to live, is heavily African American. It's 95 to 99% African American. So it is no surprise when we look at the people who are applying to live in these neighborhoods that virtually every one of them is African American. So when we tabulate it, here's one table, and here's another table, simplified as a 2x2 table with some uncertainties reflected in it. What we find is that virtually everybody applying for housing is African American. And if anything, the rejection rates for housing are higher for the very few white people who apply compared to the African Americans. In short, when you look at the people who actually applied for housing, there is absolutely no evidence of disparate impact at all. So our defense was, Judge, take a look at the decisions these facilities are actually making and decide for yourself whether there's any kind of discrimination or disparate impact here. We didn't even have to address the statistical errors that were made by the plaintiff's experts. As a result, the court agreed and granted summary judgment to the defendants, stating that they did not make their prima facie case. That the applicant flow analysis that we used to counter it was successful. Although the same issues are coming up in the Connecticut case, it's a lot more complicated, and it doesn't concern African Americans so much as it concerns Hispanics, so the data are different. That one's going to require its own adjudication. So finally, I want to share with you a collection of cases that I'm finding to be ever more fascinating. As I do more of these cases, I'm finding that there are more and more people in the country who have been accused of cheating and are defending against it. And I've now met several lawyers in Florida, California, Boston, a few other areas who are starting to make a specialty of defending such people. That gives you some indication that this is not unusual. But first, let's talk about rare events. It's a wonderful book written fairly recently by David Hand. I think is probably well known in the United Kingdom. Very well established, respected statistician, very good at writing very accessible works. This is the cover of his UK edition of his book, The Improbability Principle. The little newspaper extract, I think, does refer to a case that Professor Hand refers to, but it's not taken from his book. It's taken from, I think, a Gina Colada article in the New York Times from 1990 about a lady who did manage to win a major prize in the New Jersey lottery, not only twice, but twice within the period of 4 months. Certainly an extraordinary event. And an interesting thing about the blurb here is that although many people are willing to calculate that the chance of winning that lottery twice is 1 in 17 trillion, it remarks that maybe the odds are closer to 1 in 30, a remarkable discrepancy. By the way, the 1 in 17 trillion, I'm sure, is calculated by taking the nominal chance of buying one winning ticket in one lottery, and then separately and independently buying one winning ticket in the next lottery and multiplying them. Now to go on to the cheating, here is a list of some of the cases that have inspired these slides. I'm not giving specifics here because if I get into any of the details of these cases, many of these universities are going to come out not looking very good. And I'm going to have to admit that some of the clients whom I've defended or attempted to defend most likely did cheat. So I'm not going to reveal the details. But some of the issues that have come up are listed over here on the right. I versus I is not actually a test cheating case, but it's a divorce case involving marital infidelities, where for legal reasons, the ex-husband needed to establish that his ex-wife had been cohabiting with somebody for at least a year. The idea was that if he could establish this, he no longer had to pay alimony, which was well into the 6 figures. So it was worth him to hire a private investigator to go out to her house periodically and track the loving couple. As a result, I was asked to testify about the meaningfulness of the fact that the investigator 31 times out of 31 times that he went there found that they had stayed together overnight. The second one involved the large national standardized test accusing somebody of cheating. Usually when they do that, they offer the student the opportunity to retake the test at no cost. This student had taken the test many times, claimed that she had extreme test anxiety and was unwilling to do it again. So she contested the accusation. It didn't hurt that she had lawyers running throughout the family to pursue this case. Number three was a freshman computer science project at an Ivy League university. The computer scientists are very good at automatically finding similarities among computer code that's submitted to them. They found a remarkable similarity between DC's project and her roommate DW's project. They accused them both of cheating. DC has lots of lawyers in her family. Eventually it went to a very large, very lengthy formal hearing at which I did testify. So I was able to hear quite a bit of it, which is an interesting experience in itself. Number four involves a medical board accusing a female doctor from cheating because her husband had taken the same board exam a week early and they felt that he had revealed some of the questions to her. Number five was similar to number two, but in this case, the ETS, which administers the SAT, accused this student several years after he left high school, was a very high level college athlete, and he was at risk of losing his athletic scholarship as a result of this accusation of cheating. And number six, this is a couple well into their career, bank examiners in the state of New York who were accused of copying from each other on a bank examination civil service exam. Number seven, cheating on a midterm test. Number eight, three people accused of colluding on a final examination in a state university. So some similarities, a lot of differences. What's common to them? In every one, the heart of the accusation of cheating was a very low p-value that somebody claimed showed that copying happened or cheating happened or sharing happened or code sharing happened or something like that. On the standardized tests, there's a standard way of computing such p-values. It's based on counting identical incorrect responses. People get correct responses, identical correct responses all the time because they know the answers. The answers worth focusing on are the wrong ones. When people get wrong answers, they tend to do it for different reasons and they disagree about the wrong answers. That turns out to be a pretty good tool for determining similarity between tests. The way, typically though, these p-values are astronomically low. For instance, you saw Dr. Parnell's z-score of 224, he called that p-value less than 0.01. If you compute that p-value correctly, Dr. Parnell was testifying to a p-value that was about 10 to the minus 10,000 power. That's what I mean by astronomically low. Some experts, in fact, like to write these numbers down. I've seen reports where they write a point and say 80 or 100 or 200 zeros before they get to the non-zero decimal point, just to really impress the court about how small this p-value is. How do you obtain such a small p-value? Typically, you have to take much larger p-values and multiply them. There's issues of justice here. The dynamics are always imbalanced. It's a vulnerable person, often a student or a low-level state employee or somebody like that, who's fighting against a large institution, which holds all the cards and usually dictates the rules. The consequences for this vulnerable person are substantial. Loss of job, loss of reputation, loss of a scholarship, loss of pride. And as I've pointed out in some cases, and this is very typical, is these people come to my attention because they have the resources to defend themselves. In a particular case, here's some details of the data that were used to accuse Miss F in cheating on the ACT. ACT consists of 4 major portions, taking several hours a piece, administered over the course of a day. So the ACT summarized, they compare her test with one she allegedly cheated or copied from. And they also summarize similar statistics for many pairs of tests, both nationally, as well as pairs of tests among people who got similar scores taken at the same time in the same room. They call that analysis a local similarity analysis. And here's the kind of accusation that you can see here in the text and giving the probabilities. Highlighted by them, not by me, is this less than 1 in 10 million probability. Later in other documents, we had some back and forth after some rebuttal and some counter rebuttal on them. They were claiming probabilities smaller than 1 in 1 billion, 10 to the minus 9. And they're advancing these probabilities as the reason for why they were absolutely certain that Ms. F cheated on portions of her ACT. So some of my comments at the bottom are generalizations. And you can see some of my comments go to the fact that it is virtually always impossible to find out the details of how these probabilities really are computed and combined. Here's some more details, for instance. This is from the ACT, and the ACT is unusually forthcoming and detailed, but this is about as far as one could go. You basically have to read between the lines and figure out what the heck are they trying to do. Well, I'll show you something. This is not routine information that you're seeing here. The plot on the left is from the ACT. It was part of their counter to my defense, in which I pointed out that some of their probabilities likely were exaggerated or maybe not completely correctly calculated. And the ACT's very capable statistician, Jeff Allen, who's been working there for 20 years and made a career of this, said, hey, look, when we take a look at pairs of tests and we look at how many common correct answers they get or common incorrect answers they get, or any other number of endpoints, and we take a look at the distributions, we see nearly normal distributions. That's his plot over here. And when we plot the actual numbers we saw for Miss F and the person that we think she copied from, it's way over here. It's far off in the tail. It's so incredibly unusual. We think there's no reasonable explanation, except there must have been some kind of collusion. That ultimately is the kind of thinking that underlies all accusations of cheating. As another example, in the computer science project cheating case, the computer science professors take these electronically submitted pieces of computer code, a couple hundred lines each, and they upload them to a server at Stanford called MOS, Measure of Software Similarity, that crunches all of them and says, hey, here's all the different pairs of submissions that we have found that look remarkably similar, and we're going to rank them for you from number 1 through number gazillion. And sure enough, at the top of the rank was this pair of roommates, ranked number 1. And we're also going to tell you what percent of their elements they have in common. For DC and DW is 25%, and the next highest ranked one is 24%, and so on and so forth. So this is kind of like the outer extreme tail of a distribution comparable to the ACT's distribution. And again, they're saying, look, it is so extreme that these two probably did some copying. What we're dealing with are rare events or coincidences. And Percy Diaconis and Fred Mosteller wrote a famous article about that way back in the 1980s called Methods for Studying Coincidences, in which they articulated some basic principles. The law of truly large numbers. Rare events do happen, they have to happen, because there are just lots of events always happening to large numbers of people. They pointed out the role of psychology in paying attention to rare events, how Hidden causes can explain seemingly unusual events. The fact that the multiple endpoints one is fairly interesting, and I think I might be able to say a little bit about it, even though I'm running out of time. Well, I'll get to an example. Professor Hand's book picks up on this and runs with it and articulates it in pretty much the same ways. Professor Hand's improbability principle is really 5 laws, he calls them. The law of inevitability, that for instance, when you have a lottery, even though there might be 10 million tickets in there, one of them has to be chosen. There's got to be a winner. But if you're the one, they say, geez, what were the chances of that happening? Only 1 in 10 million. The law of truly large numbers, very similar kind of law. The Evans in Bermuda. One brother was killed by a taxi carrying a certain passenger, ran him over on the street. Ironically, just a year later, the other brother was killed in the same fashion by the same taxi carrying the same passenger. What are the chances of that happening? Well, it all comes down to how you frame it. If you ask instead, what are the chances that something that eerie, that weird, that unusual comes to your attention and causes you to think about chances? Well, the chances that some unusual event comes to your attention are about 100%. The law of selection, you're probably all familiar with this. If you can choose the events that look really strange and focus on them, then you're looking at pretty likely events. And some other laws, the probability lever, which is kind of a mishmash of all these laws, and the law of near enough, which goes back, I think, to this law of multiple endpoints. Let me illustrate this. You probably, if you live in the United States, you've probably encountered this little myth, as it were. Parallels between the lives of Abraham Lincoln and John F. Kennedy. Look at how similar the lives and the experiences of these famously assassinated presidents were. Killed on a Friday, their wives were there. The word Ford was associated with them. They each had a son who died in office. Look at the dates: 1861, 1961, 1839, 1838, 1939, and so on and so forth. All of the laws are in evidence here. There are so many facts that are available for both of these presidents that these are the tiniest fraction of the facts that we could pick out. Probably many of the others are totally different. Here's the law of selection at work. Look at the 1839 or 1838 versus 1939. What's striking here is, first of all, we're focusing just on the last couple digits of the date. We're not paying attention to the first couple of digits, but is 1838 that strikingly similar to 1939? Only if we say, well, give or take a year or give or take a couple of years. That's the law of near enough. If you allow yourself a little bit of leeway, a little bit of slipperiness to determine when two facts seem to be identical, all of a sudden, two things that look like are really rare coincidences are coincidences only because you allowed yourself the latitude to make them so. And then when you take this collection of cherry-picked, selected, near coincidences and assign a probability, maybe even a largest probability to each one, and then multiply the probabilities as if they were independent, you can produce an extraordinarily small probability. They all operate in the cheating cases. Sooner or later, you're going to see some extraordinary similarities among pairs of papers, even in the same room at the same time. Should you claim that those people were cheating? Well, you should investigate it, but how strong is that evidence really? What about if you take into account the fact that people might have studied together, lived together, worked together, have shared cultures? This has been studied. It's known that there is some kind of effect, but surprisingly, many of the studies suggest that the effect is relatively small. Even when you study together and take the same courses, it's still unlikely that you're going to get really strong similarities among papers. So the experts in cheating detection tend to discount these kinds of explanations, even though they're natural. The law of near enough really operates when we're not looking at standardized tests And you might recall, say, the little sketches that I showed as an illustration early on. When a professor gets it into her head that two students cheated, it's very easy for her to find remarkable similarities in the answers, especially if she's willing to allow for things not quite the same to be considered the same. There's a whole lot of psychological reasons why we think that coincidences are very, very meaningful. Anchoring, psychological strength, et cetera, et cetera. There's a whole list here that those of you who are involved in risk assessment, I'm sure, are deeply familiar with, because you've heard these, say, from Kahneman's work and many others, operating in, they're very great concern to people who need to communicate risk and probability to the general public and to non-experts. All right, I'm done here. But you might be interested in the outcomes of these cases. It's really a mixed bag. In the divorce case, the judge was very interested in hearing more about the probability theories, but our client saw that the judge was kind of shaking his head and he was believing the lies that were told by the ex-wife and her paramour. And so before it got to be even more expensive and time consuming for him, he dropped the case. In the ACT case, we had long testimony during arbitration, Dr. Allen and myself, and I had to concede most of Dr. Allen's points. He was generally correct and he had a pretty strong case for the cheating. All that I could really claim, I thought fairly, was that it wasn't the 1 in a billion chances. It probably wasn't in 10 million, but it was probably somewhere maybe 1 in 10,000 chances for those p-values. In other words, Mr. Arbitrator, the ACT exaggerated, but they have a fairly strong case. The arbitrator decided, though, that the ACT, through its exaggeration, was really operating unfairly, and he decided on behalf of the students on that basis. My client DC, in the Ivy League University case, lost. I thought she had a pretty strong case. I'm not really sure whether she copied or not. In the SAT case, the student prevailed in that one. In a number of the cases, the students lost. The very lengthy honor code trial, number 7, towards the bottom here with the 3 students who were accused, that trial started at 10 on a Sunday morning and went until 1 o'clock the next Monday morning. My client, the person sitting in the middle of a table of 3, was accused of being the source of all the copying, lost that case. But that was such a ridiculous kangaroo court kind of trial, a travesty of a trial, that when it was reviewed by, I think, the deans and maybe even the university president, they laughed at it and threw it out. Brief summary. In the courts, you have to keep it simple. You can't rely, at least not heavily, on sophisticated statistical analysis, but that's a lesson for us all. You saw one of the advantages of looking at a picture of a data. Do it first. Sometimes you never have to go any further. In these disparate impact cases, people are looking very, very hard to achieve statistical significance. Sometimes they look under every rock and corner. They struggle very hard. It's worth understanding all the corners that they might have looked under and did not find significance. Question every choice. Find the implicit and hidden assumptions and examine them. Beware of multiplying interdependent probabilities or p-values or throwing irrelevant p-values into that mix. It's very important to ask, what is the underlying probability model and is it even valid in its application? This is what distinguishes probabilistic reasoning, or at least valid probabilistic reasoning, from other forms. And that's it. I apologize. I went a few minutes longer than I intended, but for those of you who've waited here to the bitter end, I'm happy to answer questions and hear your comments. Thank you.
Thank you very much, Bill. Does anyone have any questions? I see a lot of round of applauses though, virtually. Yeah, thank you very much, Bill. I think that was really, really interesting, and I think the lessons that you gave at the end there are incredibly valuable. I think we have a tendency to overcomplicate things. The improbability principle book also seems quite fascinating, and the laws I think are very relevant at the moment with the amount of conspiracy theories going at the moment going around about vaccines and whatnot. I think being able to distinguish and kind of use that lens to be able to scrutinize the conspiracy theories out there is actually incredibly interesting as well. One small question from me was when you were talking about the lottery in New Jersey, for example, I was curious why all of a sudden from 1 in 10 million that the newspaper was predicting that it was a 1 in 30 chance of winning.
Yes, that's a great question. I apologize I didn't answer it. Think back to the mathematical formalism of probability.
Right.
The very beginning, you have to posit a sample space and a set of potential events to which you're willing to assign a probability. That's the framing of the problem. Everything flows out of that. If we frame the problem as, what if we take this particular lottery and sample one ticket at random, and now independently take this other lottery and sample a ticket at random, what is the chance that those two tickets were the winning tickets? That calculation gives us the 1 in a gazillion trillion.
Right.
If instead we ask, suppose that we contemplate all the lotteries in the world and examine and construct some kind of a probability model for them, which is quite possible, and ask ourselves, so the event now is not the event that I described before, but the event is, what are the chances that somewhere, sometime, we observe somebody at whatever interval of time separating them winning a major prize 2 or more times in a row? You can do that calculation, at least approximately. Obviously, it depends on which lotteries you contemplate including in that universe and how large a prize you mean by a large prize and so on. But it is possible to produce probabilities that are well into, say, the 5% range or 10% or even close to 100% range for the chance of somebody, somewhere, sometime winning twice. Or, in fact, Professor Hand describes a case of one person winning 2 major lotteries, multi-million dollars, and then a third time winning, I think, in the 6 figures, and yet another lottery. So that's where that 1 in 30 came from, I'm sure.
Yeah, no, that makes perfect sense. And yes, it's not used to hearing it from that perspective, but I completely agree. I guess those probabilities are very much subjective in the terms of what you're selecting for and the time period that you're looking at, rather than just in the instantaneous moment. Thanks, Bill. Yeah. Does anyone have any other questions from the audience? Oh, I think Alex has his hand raised. Sorry, I didn't see that.
No, no worries. Yeah, cheers very much for the talk. Really cool seeing sort of like statistics in law. I was just wondering, what kind of, I mean, are there any requirements in terms of the presentation of p-values? Because obviously, if you're like in the academic realm, if you're presenting a p-value, like you would have to demonstrate like how you collected the data that led and the process by which you obtained that p-value, so that people would be able to see that and criticize or accept that, yeah, that's a reasonable way to approach it. You said that a lot of the time it's just incredibly opaque how people conjure up the p-values in these cases. Is there not any way to sort of drill down into that more? And like, because if people are literally just multiplying p-values, that seems like an obvious.
Good questions. Let me distinguish 2 kinds of cases. The cheating cases, especially with what's going on now, is we're starting to see proprietary companies administering these online anti-cheating software examination administration apps. And those are exceptionally opaque. The ETS, the ACT, and other standardized tests are relatively transparent. The medical boards and folks like that are kind of in between. The other cases, the court cases, like the disparate impact cases, that depends on the court itself. At the higher levels in the United States, at the Supreme Court level and the federal district court levels, courts are fairly aware of the need to disclose that kind of information and be transparent about it. But having said that, when you take a look at the actual reports written by the experts, you will find that there's an awful lot of, I have to say this, mindless, unexamined multiplication of p-values. I have seen plenty of expert reports, especially by plaintiffs' experts, where they will take the same data set and look at it in many, many different ways, different kinds of tests, produce a p-value for each one of them, or some kind of probability, and then blithely multiply them as if they were independent.
Wow.
But at least they're required to document and lay out what they're done. That's what you have to do in federal court. So it's easy to identify those errors and to point to those in a rebuttal. In state courts and lower courts, it's much less consistent. And sometimes the expert is not even required to write a report. And it can be almost impossible to get them to disclose what they actually did.
And that's where seeing a p-value of like 1 in 10 bajillion, it becomes that big red flag of, well, I wonder how you arrived at that.
Yes.
Yeah.
Yes. Sometimes those are legitimate. I've heard them criticized. I've heard legitimate criticism saying no p-value of, say, 10 to the minus 80 can possibly be meaningful because nothing in the universe is that small. I'm not sure I totally agree with that, even though I'm very sympathetic with the people who advance those arguments. Because remember, p-values are always hypothetical. They're basically erecting a hypothetical model, such as this model of pulling tickets out of an urn, for the purpose of evaluation. And I'm willing to admit that under that hypothetical model, that the probability truly can be 10 to the minus 80 or 10 to the minus 10,000.
Can I ask a question?
Scott.
So when you say p-values, do you mean p-values as in test p-values, or are you
Yes.
talking about probabilities generally?
Yeah, that's interesting.
It's never been okay to just multiply p-values. I mean,
That is true. And I did say multiplying p-values in order to simplify things, so I'm glad you caught that. What goes on is the multiplication of probabilities at intermediate steps,
right,
in order to produce that final p-value that they report and use as evidence for some kind of a claim.
Okay. So I gather though that I was going to ask as a joke, where do we stand on hypothesis tests? Because there are I have plenty of colleagues who think they're illegal and that we should be strung up for even using them. So, but you obviously don't agree. You're okay with hypothesis tests and computing P's in those hypothetical situations?
Absolutely. But personally, I am very concerned about two things. One is that a p-value of 0.05 it's probably not as strong as the courts think. There have been recent proposals in response to the American Statistical Association's criticisms of p-values. Among the simplest of the proposals is simply to stop accepting 0.05 as being at all significant and use as the weakest threshold something like 1/10 of that or 1/100th of that. But where I really start foundering the use of p-values is I almost never see a report or an analysis that involves just one p-value or one comparison. I'm always deeply concerned about the multiple comparisons problem.
Yeah.
And privately, whenever I look at a p-value, the first thing I do is I consider how many, at least approximately equivalent comparisons or tests not only were made, but might even have been made during this analysis. And I automatically will divide, or really multiply that p-value by that number before comparing it to any kind of a threshold. That is a very difficult argument to advance in the courts. And so far, the courts have not even been able to address it, at least in the United States.
The multiple comparisons problem.
Multiple comparisons problem. And I have been discouraged even from raising it, both by peer reviewers and by attorneys.
Because it's too hard.
Yes, too subtle.
So I'm kind of surprised that I forget what you said. The applicant flow was one approach, and the applicant pool was that the other one?
Yes.
So that Princeton guy that you said was a good guy. By the way, is a good guy different from a good old boy? I'm a little nervous about those sorts of phrases.
Who's a Bill Foy?
Pardon?
I don't recognize.
So a good guy. Remember, you talked about the Princeton
Yes. Yep.
educated fellow who did the clearly incorrect degrees of freedom calculation. But you called him a good guy. You said they were good guys. The two of them were good guys. And
their hearts are in the right place.
right. But I mean, it's kind of freaky to hear the phrase good guy when the phrase good old boy is just left our imagination.
Oh, sorry. I didn't mean to transmit that kind of connotation. What I mean is it's very, I think all of us at some level are going to sympathize with their side of a case, with
Sure.
the underdog, with the person who is, I mean, at least at a systemic level, at a societal level, in the Alexander case and in the ensuing cases,
There's no doubt.
there is no doubt. I mean,
No
one of the first messages I had to give to the defense attorney in these cases is, look, there really is a different impact. There's a different exposure, a different effect of the United States judicial system on African Americans and Hispanics compared to whites. You're just going to have to accept that as a fact. What we have to think hard about is the extent to which this is operating at a local level and the extent to which it actually is translated into a disparate impact through the decision processes made by these housing facilities.
Yeah.
The two cases.
This Princeton guy is not a statistician, obviously. Is that right?
He does not hold himself out as a statistician.
But he should know better. He should have known better.
His work is good. I want to make this clear. Between the two of them, Dr. Wildman's work generally is difficult to impeach. I think there may be a little bit of a lean towards some results that help his case. I think that some of his analyses, when I've tried to reproduce them, have not been reproducible, but by and large, I have been able to reproduce at least qualitatively his results. So I've not strongly challenged them.
But if
Dr. Parnell's application, where the error is.
Yeah, but if ETS can lose based on their exaggerating, then surely these guys can lose based on theirs.
I'm sure that's part of the defense's hope.
Yeah. And finally, I'm a little alarmed actually, but Francis seems to be okay with this, the change from 1 in a gazillion to 1 in 30 somehow makes it all okay when you explain it in that way. But on the other hand, doesn't that really mean for us as users of statistics that we can't trust these things as far as we can throw them? Because you can, if you can change one sort of expectation like that to the other and so dramatically turn it up on its head, then what hope? I mean, David Spiegelhalter used to say that whenever you ask him a question about, statistics or probability, he has to go away and think about it. And after some time, he'll come back with an answer that may or may not be right. I mean, that's sort of where I feel too. What can we believe? Is there any way we can do things in, defensively that will lead to conclusions that are really believable rather than,
Well, Scott, those are good points, but I think they might be a little too pessimistic and you might be asking for a little too much. And where I find some comfort is not in just consuming these numbers or these results mindlessly, but in the value of statistical reasoning as a principled argument from certain assumptions to certain really tentative assumptions to certain tentative conclusions. And from that point of view, if we peer a little bit more deeply, as we just now have, into statistics like 1 in 10 trillion versus 1 in 30, we can see how both are arrived at. We can see something about the assumptions that led to each one. And each one of them in its own way gives us a better appreciation for what it means to win a lottery twice. So I'm suggesting focusing a little bit less on the numbers and thinking a little bit more about the nature and the validity of the reasoning used to arrive at those numbers. And therein, I think we can derive some insight.
Yeah, I'm sure you're right. I'm just disappointed that you're asking us to think.
I think like
Good objection.
I've always found it interesting because it always struck me that like probability and statistics is so heavily influenced by like the language of the question that you're trying to answer in a way that can make it seem really obtuse and difficult to deal with at times. But I feel
yeah, that comment really resonates with me. Often when people introduce me, they say something about my background, and I'm glad that Francis didn't, because my background is not originally in statistics. My education and early training is in mathematics. And I found statistics extremely hard to learn because it struck me as being like, say, Nathaniel Bowditch, the famous early 19th century navigator and child prodigy, who shipped on board sailing vessels at the tender age of 11 or 12 or 13, voyaged for many years across the world. At one point learned that in a few months they'd be arriving at France, and so found a French Bible and taught himself French from the Bible, only to arrive in France to realize that it wasn't pronounced anything the way he thought and he couldn't understand a word. My experience learning statistics was very much like that, but it took over a decade to get a sense that I could understand a few words and understand the principles behind them, because the language was just so foreign and seemingly meaningless. So I'm very sympathetic with that remark.
Do we have any more questions from the audience? If not, then I would like to thank you, Bill, again for your really, really interesting talk, and I've just kind of taken some notes, and I think I've got some things to mull over from that as well, which I think will be useful. And yeah, just thanks for putting up this this talk especially for us. I think we'll be sharing this online if anyone wants to share it over the next couple of weeks and things, and it'll be on our website. And yeah, thank you very much, Bill. I think I'm seeing a lot of round of applauses again. I wish we could have had you here in person, but hopefully we'll be reopening up again soon, and we'll get to see you in real life.
That would be nice to do at some point, and I look forward to carrying on these conversations.
Yeah, definitely. All right. So thank you very much. I'll end the call here.